Laura Harbison, broker-owner of Realty Executives Southern Nevada Properties, and this is Real Estate Today. Today I have Kerstan Hubbs of Essential Legal Services here to speak with us about the basics of estate planning and just to give us some, an overview and some tips. Hi, Kerstan.
Hi, Laura. It's a pleasure to be here today and to speak with you about estate planning, especially in regards to real property.
Yes, absolutely. So can you kind of give us a little bit of an overview of what people should be thinking about as they're doing their estate planning?
In general, estate planning reaches other avenues outside of real property, but sometimes a person's their main asset may be real property, and so then it becomes obviously something that we need to hone in.
Mm-hmm. But their home is typically their largest asset.
So basic estate planning for me, when an individual comes to my firm, is we're looking at documents that are needed upon death, which will typically be a living will and testament. If they have sufficient assets, we're going to start to look at the first step is revocable living trusts. Mm-hmm. We also have in the state of Nevada non-revocable or irrevocable irrevocable trust, but we also call that the spendthrift protection trust that many individuals are aware of. But that one is a little bit more for long-term estate planning and for building wealth over time. So the primary vehicle is always the living revocable trust. And then we usually look at the durable powers of attorney for medical and financial issues and any other conveyance mechanisms that need to be done in order to convey property into trust thereafter.
Very good. Very good. So when in someone's life should they be working on this type of thing?
Anytime an individual starts to accumulate any wealth, they should start to think about planning ahead and preserving it for the individuals that they want it to go to should something unfortunately happen to them. One of the main steps in life in which I see individuals start to think about estate planning is typically when they purchase large acquisitions or they start to have a family.
Mm-hmm. Very good. Yeah, I actually was watching something the other day, and it actually hit home because unfortunately I was in this situation too, is anyone 18 years old or older, is legally an adult. So everyone should have, for instance, you mentioned the power of, the medical power of attorney, and the financial power of attorney. If you have a child or a grandchild that gets into a situation, a car accident or what have you, and is incapacitated and needs decisions made for them, no one can legally do that without having something in place.
That's correct. So it's never a point in which you're too young. So starting 18 years and up, 18 years is when you have capacity to engage in a durable power of attorney. A durable power of attorney, too, is different than a limited power of attorney or a regular power of attorney, meaning once you become incapacitated, the power of attorney continues forward until you pass away.
Mm-hmm. Or become no longer incapacitated.
True. Yes, true. Or until you revoke it at a later date when you do have capacity as well.
Yeah, very good. So not everybody has a trust. Some people just have a will, those types of estate, the estate planning. What is the difference between a will versus someone who has a trust?
So one of the main objectives of a trust or putting together a trust is to avoid a process that you would have even if you had a will or did not have a will. And that is what we call the probate process. Mm-hmm. That typically occurs upon someone's passing and when they have property and debt that's kind of left as is. Mm-hmm. And we need to know how this property and debt will be assessed once they pass away. It's a very difficult process because loved ones are usually grieving the person who passed away, and so there's a lot of stress at that time. And then they have to go and usually engage counsel and file petitions in court. And depending on the size of the estate, the longer the process. So large values estate can take years in court at time. Smaller estates can move much more rapidly. Different processes for the value of the estate. Okay. So by creating a trust during your lifetime, your family will avoid the probate process because essentially you will be putting all your your estate into the trust, and you will essentially own nothing. So upon your death, you simply say, I have no property. Everything that I did have is in this trust, and a trust in Nevada can survive for 395 years.
Oh, wow. 395 years.
Yes, it is a very long time. And
Did not know that.
we have a lot of different tools in the state of Nevada that allows for legacy planning over time, but just a general trust in the state of Nevada will last 395 years.
That's amazing. And for probate, isn't there a limit? You know, for instance, you have to have so much in the way of assets in order for it to be required to be probated.
Yes, typically you need to have at least, I believe, $25,000 in assets.
That's all.
For you to have a basic affidavit. And then it will go up into different increments of wealth for a set-aside, probate process, or a summary disposition, or a general disposition. So, and typically that correlates to the amount of assets you have. Once you get over $300,000 in value, you will be in the general probate process.
Okay. So, and that people don't realize it, you know, how quickly you can get to that number.
Sure.
Yeah. Especially if you have a home, but even some people who don't have a home.
Right, that is correct.
Yeah.
And it is can be a little bit time-consuming with the probate process. You're going to be working with banks. You're going to be working with stock funds, individuals who want medallion certificates for transfer. It can get very difficult to get through that process, trying to meet the requirements for every financial institution out in commerce.
Yeah, so you definitely have to have an attorney to guide you through that process.
Yes, that is that is
So,
usually recommended.
Right, which would be an additional expense that can be avoided in the trust situation.
Right, because an attorney under law can take a certain percentage of the value of your estate under statute. And so, you know, if you don't want to pay that expense, especially if you have a very large estate, it's much better to have a trust.
Okay. That's good. That makes a lot of sense. So, and those are the types of things that you help with. You help people with their estate planning and trust if they're interested in that, and all their different powers of attorney and that type of thing. Right?
That is correct. I help people put together a comprehensive estate plan, and at times people will need to just come in and have incremental work done. Maybe they already have a estate plan set up, and that's another important aspect of an estate plan, is that it is a dynamic process. As we acquire more assets, as we sell more assets, as our family grow, our estate changes, and we need to think about that over time, especially as our children start to phase out in age. We may not need guardianships anymore, and we may not want the individuals that are in place taking care of our assets after death, because now our children are old enough to manage that on their own behalf.
Well, I sell a lot of homes up in the age-restricted communities, and one of the things that I've noticed is often the trust was set up, 20, 30 years ago, and it's never been reviewed or updated. How often should someone have their trust updated?
I would say every 5 years is a good time to look at it in general. But there are also other times and circumstances in which you should immediately look at your trust. If you have children, if you get a divorce, or you get married. And of course, if you acquire a lot of assets or need to get rid of a lot of assets, you may want to revisit your estate planning.
Okay, very good. So that I definitely, because like I said, I see it all the time. What about now? A trust, what if somebody owns properties in multiple states? Because a lot of times, we are a lot of people transfer here from out of state, that type of thing. Is the trust state specific, or how does that work?
Usually the trust will be created in the state in which you're domiciled, but it can definitely hold property out of state.
Okay. So if someone has moved here for retirement, that type of thing, they could still form their trust here, but maybe they still have a home in Michigan or something like that. They could deal with that.
That's correct, Laura.
So very good. Well, if you have any additional questions, our information is below. You would want to give Kerstan Hubbs with Essential Legal Services a call. She can answer your questions. She can help you out if you have an older trust you'd like reviewed or updated, anything like that, or any other questions having to do with estate planning. So again, I'm Laura Harbison, broker-owner of Realty Executive Southern Nevada Properties, and this is Kerstan Hubbs of Essential Legal Services, and we hope to hear from you soon.
Thank you.